Hello, I'm Andy Agapangelo. I'm the founder of the campaign group Transparency Task Force. We are a UK-based certified social enterprise. Although we are UK-based, we actually have members in 21 countries around the world. Our purpose, our formal purpose, is to promote ongoing reform of the financial sector so that it serves society better. We believe that the financial industry is profoundly important to the well-being of society, to economic stability, and to political stability too. I became a full-time campaigner with the Transparency Task Force after I set it up in 2015. And it's my genuine belief that the financial industry needs to become more transparent, more truthful, and more trustworthy. It's fair to say that over the last 7 years or so, gosh, more than 7 years or so, 9 years or so, time flies, I've become increasingly skeptical about the level of integrity and ethics in and around the financial industry. And frankly, I'm not just talking about some of the companies here. I'm also talking about the regulatory framework that is supposed to be governing it and providing oversight. Transparency Task Forces run dozens and dozens of events where attendees end up concluding quite logically that there really are some systemic flaws in our system. Describing SLAPPs as a systemic flaw is perhaps quite apt. SLAPPs, or strategic lawsuits against public participation, are, as you probably know, a device, a tool, an instrument being used by the wealthy and the powerful to block freedom of speech and to block truth getting to the surface. They are therefore an anathema to an organization such as the Transparency Task Force. We're built around the idea that sunlight is the best disinfectant. That phrase was first used by Justice Louis Brandeis in his 1914 book about misconduct in the banking sector. Justice is a primary thing for social well-being and for societal equilibrium. And if we have things that are preventing the sunlight being seen, preventing the truth getting out into the open, then it's obviously highly, highly problematic. I'm going to read out a few notes about David's book and then pass on to David to introduce himself. The book's title is Buying Silence: How Oligarchs, Corporations, and Plutocrats Use the Law to Gag Their Critics. This timely and important book focuses on the controversial issue of SLAPP cases, which are designed to censor, intimidate, and silence critics by burdening them with aggressive opposing lawyers, heavy legal costs, and inquiry agents until they abandon the case. David Hooper, a veteran media lawyer, explores how the power of money enabled the very wealthy to crush their critics, and he outlines the tactics they used. He examines how billionaire oligarchs, often ex-convicts and linked to organized crime, have tried to launder their reputation in this country by suing for libel, and now how they have found lawyers only too happy to profit from their troubles. It's going to be a fascinating session. David's going to be speaking for 20 minutes, maybe a bit longer or so, and then we'll open up to conversation so we can really gain everybody's insights on this remarkably important topic. As far as the Transparency Task Force is concerned, we want to do everything we can to minimize the egregious use of SLAPPs. They are part of the enemy, for want of a better phrase, and depending on how cynical you are, they are a significant contributory factor to the collapse of trust and confidence in the establishment because, frankly, money is, in inverted commas, buying justice. A big problem, a very big problem. David, we're very grateful that you're here with us. Can I please invite everybody to show our appreciation for David for being here and, of course, for writing this book that we're all about to learn a lot about. Thank you very much indeed, David. You're very welcome. You're amongst friends. You're with people here who understand these issues in broad terms. We'd love to hear your insights and your background. Over to you, David. Thank you very much indeed. Thank you.
Well, thank you very much for that kind introduction. What in outline I want to deal with today is why slaps matter, the origin of slaps, the ingredients of slap actions, who are the slapsters, in which countries do slaps arise, and attempts to change the law, and consider whether slaps is still a continuing problem, and if so, how we should change the law. Well, why, first of all, does it matter? It's not just a question of freedom of speech. It's the other side of freedom of speech, which is the public interest and right to know, and the right to information. And the problem with slaps, we hear of some of the more famous slap actions, is that it's the tip of the iceberg. When the distinguished MP, Dame Margaret Hodge, wrote a book about corruption in public life, needless to say, that generated a slapster, somebody who had um, been subject to a jail sentence, although, like all of them, he said he was wrongly convicted and it was a political frame-up. But like so many of them, he was a benefactor to the Conservative Party and gave money to all the appropriate charities. And you got there the very respectable House of Chatham House. They just felt they couldn't bring the libel act. They couldn't publish it because they faced possibly £500,000 in legal costs if they went ahead. And in fact, in the end, it was published under parliamentary privilege. And as a good example of the problems of SLAP, I don't know if any of you have come across the investigative journalist who now runs a company called Offshore Alert, called David Marchant. He was telling me that he has been sued as a result of his investigative journalism in the USA, the Cayman Islands, Canada, and Panama. And his case in the United States perhaps just is worthy of a mention. He wrote about a man called Mark Harris, who was running a $1 billion Ponzi scheme. And when this was exposed by Mr. Marchant, he got sued for $30 million damages in libel in Florida. But he had the last laugh in that Mark Harris not only failed in the libel action, but ended up serving 17 years. And the other thing to bear in mind is that the UK is generally considered to be the worst country for slap actions. It attracts Maltese politicians, as was shown in the scandal that arose after the murder of Daphne Galizia. It has encouraged German fraudsters, as in the FT and Wirecard case, and no end of Russian and former Soviet bloc oligarchs have sued in this country. And it's worth perhaps mentioning as another example of why slaps matter, very briefly, the Wirecard case. It was a case of some interest to me because the FT were hacked by the same hacker that I got hacked by in a slap action of which I was on the receiving end. But there you got Wirecard using all their money, trying to bring criminal prosecutions against the FT, accusing them of manipulating a market, intimidating their sources and their journalists, putting the FT building under surveillance. And what the FT had done was they had exposed the worst ever fraud, financial fraud in Germany. And they were the only ones who did so. The accountants, EY, had just failed to notice that $1 billion, which was said to be in a bank account, simply wasn't there. It was investigative journalism of the most important sort. And most of the senior executives of Wirecard have either fled Germany to Russia or alternatively are standing trial. And the other thing about SLAPP actions is that they do seem to be on the increase. And the problem of SLAPP actions is that they corrupt the law and they also corrupt the lawyers because there's a lot of money on offer. And one really wants to see it in context of an increasing amount of corruption in public life, well described in Mr. Bauer's book, the title of which was momentarily The Downward Spiral, which sets the picture of quite how much corruption there now is. And this is a form of corruption. It's SLAPP actions are the weapon of bad actors, and it leads to a host of bad practices in the way cases are presented. And it brings in things like illegal hacking, intimidating private investigators, and PR people who are used not just to defend the legitimate interests of a company, but to denigrate and intimidate the opponents. And that was very clear in a case brought by a man called Mohammed Amersi against the former MP Charlotte Leslie. So who then are the slapsters? Well, politicians. SLAPP action has even been brought in this country by Trump, who has been called the litigator in chief in one of the books about him. And the Trump action, which he was bringing against Christopher Steele, who had prepared a dossier on whether or not the Russians had interfered with the US election of 2016. But it's a good reminder that SLAPP actions cover not just libel actions, but also data protection claims and privacy claims. Trump's case, pleased to say, was thrown out. Another politician who brought SLAPP action trying to cover up the fact, particularly as he happened to be Chancellor of the Exchequer at the time, that he had forgotten to pay 3.7 million tax and had to pay a penalty of 30% of that sum on top of the tax he hadn't paid. And you also get SLAPP actions brought by companies. One of the earlier cases I dealt with was Nomura. It was a good historical book, and it described how, and we're talking way back in the 1990s, when the practice was more or less ending, of how they used to deal with organized crime and insider dealing, which seemed to be the way things were conducted in Japan. But they tried to sue and even close down the publishers of Bloomsbury, who had just started. And they spent about 2 million on the libel action, but it got them nowhere. You also got SLAPP actions brought by drug companies. The first one was brought by Upjohn against a Scottish professor who had exposed how they had falsified their drug tests. And of course, you also got the same from Purdue Pharma, who were the Sackler company, who tried to suppress the excellent book Empire of Pain by Patrick Redden Keith, who exposed what they had been up to and their corrupt practices. And of course, the other people who use it are fraudsters, of which perhaps the most notorious is Ruga Ignatova, who produced the OneCoin cryptocurrency, which led to her becoming being placed as the FBI's most wanted woman. And that was a good example of the harm that SLAPP actions do, because the lawyers who had been hired by her, a well-known firm called Carter Ruck, managed to persuade the FCA to withdraw the warning notice that they had produced. So it meant that she was able to continue to sell this scheme, and it was sold particularly to people in Bangladesh, who, as you may well imagine, had no spare cash, and it caused great financial hardship there. And it was a very good case of where one said, well, before these excellent lawyers came on the scene, they might possibly have looked into the facts, because it was so obviously a Ponzi scheme. I think most people, when told that their investment is going to increase by 200-fold in 3 years, might smell a rat, but apparently not. Apparently not lawyers. And you also have had the same in Malaysia with a man called Joe Low, who's now fled to China, having robbed the sovereign wealth fund of Malaysia with the assistance of Goldman Sachs, who had to pay penalties of 5 billion, and some of their people have faced 10-year jail sentences. Again, trying to stop a book exposing all this called $1 Billion Whale, and being prepared to spend millions on it. And the other problem is that it has meant that a lot of books, non-fiction books, are just not being published at the moment, because you think of Catherine Belton's excellent book, Putin's People. There were 5 law firms bringing claims, and they all suddenly brought claims after it was recommended by Navalny, and that apparently incensed Putin. And so all the oligarchs started suing. And then Tom Burgess had the same problem with Kleptopia from the mining company ENRC. 6 law firms started issuing threats. And he pointed out that his book was 300 pages. The lawyers' letters ran to 600 pages. And HarperCollins faced a liability of about $5 million. Now, they're a large publisher, but even that is far more than companies can really afford to risk. Now, the origins of slaps in this country can be traced back to the likes of people like Maxwell and Fayed, and Russian oligarchs such as Luchansky and Berezovsky. With Luchansky, he had served 7 years. He was described by Time magazine as probably the most pernicious unindicted criminal, but that didn't stop him being able to bring libel action against the Times newspaper, which substantially he won, our libel law being so friendly to claimants. And the Berezovsky case, again, he was somebody who had sort of laundered his reputation in this country, but it was a case that should never have been brought. The 2 plaintiffs, Berezovsky and his accomplice, both ended up getting murdered, and they also murdered, or Berezovsky also appears to have hired Chechen gangsters to murder our client, Paul Klebnikov, who was the Russian editor of Forbes magazine. I mean, what are these people doing, bringing reputation laundering exercises in this country? What then are the ingredients of slap actions? Well, one is that very often there's no real interest in the actual remedy, in vindicating your reputation in the way that you or I, if something dreadful had been said about us, which was untrue, would want the record set straight. They basically want to crush their opponents and to silence them. And the other ingredient is the enormous disparity of wealth. So you get people who've often made their money in very dubious circumstances, prepared to throw endless money at cases and give their lawyers a more or less blank check, which goes down quite well with libel lawyers. And you get lengthy letters being written, a lot of applications being made to the court. And although often the cases are thrown out, as happened with Bill Browder, when mysteriously he was sued by a Russian policeman who had been put up by the Soviet state because he had he had left Russia because after people had tried to obtain the funds of his Russian company by fraud. And yet you got lawyers perfectly willing to bring the case. The case was rightly thrown out by a robust judge, but by then it had been running for a year. It had cost Browder probably the best part of £1 million, and he was left with a bill of £662,000, which the other man was ordered to pay. But of course, he had rushed back to Russia. And the other ingredients, as I've mentioned, is you get increasing use of hacking, public relations people, and private investigators who aren't necessarily investigating wrongdoing, but they're intimidating, surveillance, going into people's background, and generally discouraging them from pursuing the case. And other ingredients, which again I briefly mentioned, are that you find that these guys have been doing other things to launder their reputation, like donations to charities and political parties. And which are the countries where slap actions have been brought? Well, I've already mentioned Malta. At the time that Daphne Galizia was murdered, there were 43 cases against her. And under Maltese law, a lot of those cases still continued despite her death. The criminal libel ones didn't continue under Maltese law, but 34 civil cases did. And it was English lawyers who were orchestrating it. You get cases from Russia, you get cases from USA, Azerbaijan, Uzbekistan, Sweden, Germany, Greece. So that was a case I was involved with, a Greek newspaper, Greek language newspaper sued in this country by a Greek-Israeli. Clear slap action in my view. And in fact, when I gave evidence in Greece, I was subject to a slap action, and I'm now being sued for the evidence I gave to the Greek Supreme Court, which the Greek Supreme Court accepted as being admissible. But that's all part of life's rich tapestry. And there's also currently a particularly striking case against investigative journalists out of Kazakhstan, where it concerns a charitable fund for the benefit of Kazakhstan, where the companies are all seem to be based in Nevada and Delaware. So what on earth it's doing in this country, other than trying to silence investigative journalists, I do not know. Now, there have been attempts to reform the position. The Conservative government in 2023 produced the Economic Crimes and Corporate Transparency Act. That, however, required that the slap action had to deal with economic crimes, and it didn't cover all the cases. It wouldn't have covered the Carol Cadwallader case, even though the judge ruled that wasn't technically a slap, nor would it have covered the case brought by the man who founded the Wagner Group, Evgeny Prigozhin, because that had nothing to do with economic crimes. It was very complex, and because you had to work out from looking at a schedule whether it was an economic crime, and you also had to prove that intention on the part of the claimant to bring a slap action. And intention is always difficult to prove. Wayne David, the former MP for Caerphilly, was going to bring in a bill which would have simplified it, and if it had been duly amended, it would have dealt with SLAPP actions. There are plans to bring in rules of court which should flush out SLAPP actions quickly, because what one needs is for cases to get before the courts quickly when an experienced specialist judge can weigh up the public interest in the case going ahead. Because I mean, a lot of these people have already vindicated their reputation, or that they really aren't going to be caused any significant damage by it. They've got public relations people. The publication may not be that extensive. It may be on social media. The present position is that there isn't an anti-SLAPPs bill in the recent King's Speech, simply because there are so many other bits of legislation. But it will eventually happen. And in the European Union, there has been a directive which was approved by the European Parliament in April of this year, and there has been a resolution by the Council of Europe which should be implemented by the European Court of Human Rights. These cases are still continuing. Some people might be quite surprised that Crispin Odey of Odey Management has recently brought a claim in respect of allegations of sexual harassment, which led to him parting company with his company. You've also got, on this occasion, a Labour donor, Dale Vince, bringing actions against Guido Fawkes and suing in Ireland. And again, there seems to be an element there of wanting to silence critics. I mean, obviously it is a political enemy, but it's a bit difficult to see what harm is actually being done. He's been vindicated. Any suggestion that he supported Hamas has been clearly cleared up. And really, these cases ought to be stopped in their tracks when they're not necessary. Clearly, in some cases, people must vindicate their reputation, but one really wants a simpler form of litigation where it comes before a judge who assesses it quickly, because the view I've formed over my career is that spending masses and masses of money doesn't produce better justice. Arguably, it produces worse justice, because one side is going to run out of money before the other. And what you really want is justice that is swift and cheap, and also accessible not just to the very wealthy. And finally, if one wants to look to the country where they have got a good working model, one should look at Canada, where they've had these anti-SLAPP laws, and they balance the rights of the two parties, the public interest in knowing about these matters against the need for a person to vindicate the reputation. I'm sorry, I've slightly overrun my 20 minutes, but
not at all. Not at all. It's been a real pleasure listening to you speak. Before we do anything else, folks, can I please invite everybody to join me in thanking David for setting out those thoughts in such a clear and compelling way. David, you've boosted my knowledge of SLAPPs manifold. You really have. Thank you. We're going to invite Roger Mullin to respond to what David has said by talking about his own work in the SLAPPs field, particularly in what Roger has managed to do north of the border in Scotland. Roger, if you wouldn't mind briefly introducing yourself and bringing everybody up to date with what you've been doing regarding SLAPPs in Scotland, and perhaps most importantly, why this topic matters so much to you. Thank you, Roger.
Yeah, well, First of all, thanks very much, David, for your talk. That was excellent. When I was an MP, 2015 to 17, I became involved and interested in financial crime type issues. And I pursued in particular trying to deal with a thing called Scottish Limited Partnerships that were at the forefront of huge financial crimes such as the Russian laundromat and other things like that. And I slowly became aware that part of the problem for investigative journalists I became quite closely involved with was that they were being silenced precisely by the things that David was talking about. So some of the worst cases of right to this day never come into the public domain because of threats to newspapers that can't afford to take the risk of going to court, even though they would be very confident about the worth of the stories. And so this concerned me. When I stopped being an MP, I remained interested, wrote about it a little bit, but became concerned that the campaigning to reform the law was focused only on England and Wales law. And what was being ignored was the effect on Scotland. Now, there were two things related to Scotland that I was concerned about. First of all, I became more and more aware that there were slap cases of different sorts based within Scotland itself. So we needed to protect Scots law from abuse and citizens of Scotland. And secondly, the concern was precisely because of the progress David talked about in getting the issue started to be dealt with in England and Wales. My concern was if the law was sorted eventually in England and Wales and nothing was done in Scotland, it would simply encourage so-called libel tourism. They would move from one jurisdiction to another. So I was concerned about it from that point of view. So very briefly, what did I do about it? Just over 2 years ago, I raised a petition with the Scottish Parliament to ask the government through the Scottish Parliament to address the law of Scotland in relation to slaps. There was quite a lot of hurdles to go through. It's easy to raise a petition with the Scottish Parliament, much easier than at Westminster to get action, but it does take a bit of time. So I got through, it took about 2 years to get through a whole series of hoops, getting it considered by the Petitions Committee on a number of occasions. And then eventually, with all party support, there was an oral hearing held in April of this year, where myself and a number of other bodies like Aberdeen University's a legal group who focus on slaps and the like, and we presented evidence to the Scottish Parliament. 2 weeks after that, so this is very recently, the government minister came before the committee to respond to my petition, and the government minister accepted all of my arguments and have decided to adopt my petition. Within 2 weeks of that statement being adopted, they indicated in public that what they were about to do was launch this autumn a pre-legislative consultation to reform the law in Scotland to deal with the issue of slaps. So I'm pleased in that sense that progress is being made in Scotland. We have probably overtaken the UK because Wayne David's bill, of course, fell because of the general election. So the new government is going to have to start the legislative process for England and Wales again at some point. And as David said, it wasn't listed in the King's speech, so we're uncertain about the time that will be involved in that. But I'm hopeful that things will move forward later this year in Scotland. If I just mention some of the things that have been happening within Scotland and related to what David was saying, if I pick up your example, David, of what was it called again? The Bitcoin, OneCoin.
One point.
Thing that happened there. there was a lady of very modest means living in a council house in the west of Scotland, whose dad died and in his will left her £15,000. She then was, as I would see it, entrapped into putting all that money, and she was partly disabled, so living in benefits, all that money invested in this scam operation. She eventually found out through contacts in the United States and the like that she had been scammed in this Ponzi scheme, as David described it, and set up her own little Facebook group to warn people of this and to discuss what happened to her. She then one day, not long after she had been operating her little Facebook group with no resources, received a legal threat from Carter Ruck on behalf of those running the scheme. And obviously she was not going to go ahead and defend herself or anything like that, because she didn't have the means to do so, nor the knowledge. But the harm, the huge psychological harm done to that poor lady was tremendous. And, you know, there was an example where it's not just people of real significance that can be caught up in this type of action. It can be honest, innocent people trying to do their bit to help fellow citizens who can be attacked in this kind of way. And there's plenty of other examples. I was interested that David also mentioned the Scottish professor. I know of a number of academics in Scotland who have been attacked by SLAPs to try and prevent them publishing their research. And I know of one case in particular from the university that I'm an honorary professor at, where a number of years ago, they received a threat from a major corporation demanding access to research that they had undertaken to try and make sure that nothing was going to be published that would have been against their interests. So although I was particularly aware and remain very concerned about the oligarchs and those in the financial sector who have got significant means to try and prevent people having a right to know about their actions. It's as well to be aware that it also involves a wider number of people in society and wider groupings of people in society. So I'm very grateful for what David has done. And basically, I'm trying to do my own wee bit in Scotland.
Roger, thank you, as you often do, for contributing to tonight's conversation. It's wonderful that you've managed to do what you've done north of the border, and I really do hope that parliamentarians in England and Wales and Northern Ireland can, in some way, look to replicate the success that you've had. This is clearly a massive social justice issue that really ought to be front of mind for all the parliamentarians that are committed to fairness and transparency. There are simply far too many David versus Goliath battles going on where people are having to fight to get the truth out into the open, sometimes at real risk for themselves. And that risk comes in many different forms. I might elaborate on that later. Roger, thank you very much for your contribution. Just before you go, I know you'll be going shortly. David, can I please just jump back to yourself, and perhaps Roger said something or that you may want to reflect on, comment on, and please do finish off whatever you'd like to add in relation to what Roger has said. Thank you, David.
No, I think the very important thing Roger said is that people shouldn't be able to pop over the border and bring actions. Unfortunately, you do get that happening in Northern Ireland, where they seem to be fairly sympathetic to claimant in that jurisdiction. But certainly during the time of official secrets, one did quite often have people nipping up to Scotland to publish books that the English government weren't allowing to be published. I mean, the Scots were on the side of the angels in that regard, but it is on the face of it quite odd that there shouldn't be a degree of uniformity, on what can be published, and that you can read a Scottish something in the Scottish newspaper legitimately one side of a border, but not the moment you get to if you take it to Carlisle, you're committing some offence or liable to be acted against.
David, thank you. Roger, thank you. I made a note in the chat earlier. I'd be keen to thank you, Roger. Thanks for being with us while you could. Have a pleasant evening, sir. I made a note in the chat that I'd be keen to hear from Paul Birch about Malta. This is a bit embarrassing for me because my mum is from Malta, and I have to say, over the last few years, through Paul Birch, I've been discovering how what's the right word? How dodgy, shady Malta seems to be. It seems like it's riddled with corruption, if I'm being frank about it. That poor journalist whose life was taken because she was trying to expose shenanigans, let me call them, was really, really tragic. Paul, would you take a moment, please, to introduce yourself and talk in general terms, nothing too detailed if you don't want to, talk in general terms about the sorts of things that the Times of Malta have been up to and all that sort of stuff. Paul, just spend a few minutes telling us about your perspective on these sorts of issues in Malta and journalism and exposing the truth over there. Thank you, Paul.
Yeah, good evening, everybody. I'm Paul Birch. I'm a victim of what has now become a huge issue with Cure-Ops pension scams. And it all started off back in 2011 when I was persuaded by a now absconded IFA to transfer my pension into a HMRC recognised and Malta Financial Services authorised, regulated Cure-Ops pension because we were in the process of emigrating to the USA. David mentioned the assassinated journalist, Daphne, and she, just prior to her assassination, had identified numerous huge financial scams involving the then Prime Minister of Malta, a guy called Joseph Muscat, and several of his leading cohort or parliamentary assistants and so on, two of whom in 2011 were sanctioned publicly by the United States, the United States Department of State, for having been involved in significant corruption involving government agencies. And the whole thing, as Andy has just intimated, basically demonstrates levels of corruption and collusion from the Prime Minister downwards, and the political appointments that have been made by both the former Prime Minister and the current Prime Minister to ensure that, to all intents and purposes, these excesses and the corrupt dealings have been buried. And when they have been exposed, as David said, the journalists and those involved have been issued with slap after slap after slap, as the government has done its level best to bury it deep below the surface. The most recent development in Malta was last week, when 13 senior people from the US government have now been charged and are going to trial for involvement in corrupt dealings, including the former Deputy Prime Minister. Also, the governor, another one cited is the governor of the Bank of Malta, who also sits on the European Central Bank Committee, and he is refusing to resign because he said that under European law, until he's been proven guilty, he has there's no legal mechanism for him to be forced to resign. So the scale of corruption is mind-boggling. I mean, I started off as a lone voice and started a litigation case in 2018, which is still ongoing. And without putting too fine a point on it, the whole system is corrupt because every time you turn, there is a political appointee in a position who can ensure that the whole thing stops and is just buried. And yeah, but what has also happened is that, as I say, I initially thought I was the only one, but this thing has grown like Topsy, and there are 31 recognized cure-up schemes in Malta, and I think it is safe to say that probably half of those at least are subsidiary companies of UK AIM listed stock exchange companies. We've got international banks involved who've been laundering money, well-known accountancy firms who are implicated by having signed off fraudulent audited accounts. It's staggering. I mean, if you try and explain it to somebody who hasn't been involved in it, they think you've probably sort of been sniffing something that you shouldn't have been and have now become totally deranged. But as Andy can probably confirm, I've shared stuff with him with documentary proof to support what I've said. And the slap thing is such, and David, I think, has alluded to it, that although this information has been shared with numerous news agencies, not only in Malta, who in fairness to them, the Times of Malta and the Shift News have run with it, but international media outlets are frightened to death of the implications of what is now out or should be in the public domain there, because they know that slaps will result.
Well,
I know I've rambled on a bit, and
no, you've given us some the bone and some meat around that as well. It really does help people to understand that we are not talking about some abstract notion here, some cerebral device that only happens in the ether. We're talking about real people's lives being ruined, wrecked, call it what you like, preventing them from getting the justice they know they should have, preventing them from being able to expose criminality, fraudsters, tricksters, cheats, through slaps and related affairs. This is serious stuff. It really is serious stuff. Paul, thank you very much indeed for sharing that. And
you're welcome.
As you've heard me say many times, I feel my mum is Maltese, and I feel so bad about what's happened to Malta. So much it's riddled with Russian money. My dad's from Cyprus, and another country that isn't exactly a bastion of good ethics. John Bowers KC is with us. John's just put his hand up. We'd love to hear from you, John. And folks, John's going to be back with us on December the 10th, I think it is, to talk about his book, Downward Spiral, which is about, to my mind, a very important related matter to do with the collapse of trust and confidence in ethics and integrity in public life, something which is a huge issue for the Transparency Task Force. Paul, thank you very much. John Bowers KC, please do take a moment to introduce yourself and share your thoughts. Thank you, John.
Yes, thanks very much. Very interesting talk, David. I wonder if I could ask you a couple of points. Firstly, could you talk about the responsibility of solicitors in relation to bringing SLAPs? Because I believe that there have been some restrictions on people. And of course, in the Zahawi case, I think there was actually some criticism of the solicitor who wrote the letter trying to silence Dan Needle. The other thing is whether you could comment on the fact that bringing a defamation action, particularly in the SLAP area, can actually lead to much more consideration of the complaints. For example, in relation to Mohammed Amersi, I don't suppose many people would have heard of him if he hadn't brought the claims. I wondered if you could talk about that dynamic. Thank you.
Thank you, John. Lovely questions. David, over to you, sir. Thank you.
What's been done by the Solicitors Regulatory Authority since 2022 has been pretty important, because they have laid down rules that you must not write endlessly aggressive letters and very lengthy letters and make worthless applications. And more recently, they have taken up something that I've been lobbying for, namely that when solicitors use inquiry agents, private investigators, they should keep them on a very tight leash and should supervise it, rather than, as happens at the moment, they just simply say, well, you mustn't do anything illegal, probably giving a slight wink as they do so. I think it has changed the way people are going to handle these cases, and letters have become a little less aggressive. And the SRA have investigated 70 complaints. I think they've been a bit overwhelmed by it. I think they've said that 2 of them so far, they have found that there is a case to go to the Solicitors Disciplinary Tribunal. And if there are adverse findings there, that could well make a difference. They are under-resourced. And of course, the problem is you probably, I mean, they can't change the law and they can't change the practice, but it's certainly one of the important changes. And the other important change, which hasn't come through yet, they're going to change the rules of court, which might make it more difficult to bring SLAP actions. But I think you actually need something rather more fundamental. You need to give to the public interest defense, which is pretty difficult and always pretty expensive to provide. I mean, with Mohammed Amersi, that is certainly true, but in 99 cases out of 100, Amersi would probably have got his judgment without too much difficulty. It so happened that the person he went after did have insurance and did have insurers who were prepared to stand by her. I mean, it is one of the dangers of a libel action that if you have any dirty laundry, it may well be hung out to dry in court. But it's not very often that happens. And I think it's not an enormous deterrent to people bringing SLAP actions, because a lot of these SLAP actions, people know that they are connected to organized crime or have served sentences for dishonesty in Russian jails, or with Evgeny Khashoggi, you knew that he was the murderous runner of a mercenary group. But I mean, they still bring actions simply because they're pretty confident they're going to crush their opponents. But just once in a while, one gets a bit of Schadenfreude when they fall flat on their face. But the number of people like sort of Bill Browder or Charlotte Leslie who take cases on are pretty few and far between. And even in the Catherine Belton case, where it seemed to me she had pretty good defences against the claims, and the claims didn't have any substance. They were just so expensive that most cases get settled in the end because it's always pretty uncertain what the outcome of a libel action's going to be. So the claimant has most of the trumps in his hand.
Thank you very much indeed. This is a very, very interesting conversation. We'll check in with some other comments and questions in a moment. I can see Nigel put his hand up. We'll go to Nigel shortly. If I may, folks, I'd like to just spend a few minutes trying to explain how, from my point of view, this matter is particularly important in Transparency Task Force's area of interest, which is, of course, the financial services sector. I'm going to do this by way of referring to some data. Some of you would have seen this before, so please just bear with me whilst I share my screen. I'll put a link to this database in the chat, so you can all have a look and have a play in a moment. The database is called Violation Tracker UK. I chair the UK advisory board of this database. It's basically an aggregation of publicly available data from the various regulatory authorities. You can search it in a 1,000 ways. The search I'm going to show you is this one. If you click on Parent Industry Totals, it will first of all give you a list of all the industries in the UK ranked by how much they've been fined. And as you'll see at the top of that list is the financial services industry. Now, I could talk for ages, I won't, but I could talk for ages about how the financial services sector is trust dependent and therefore ought to always behave in a meticulous, immaculate way to defend its reputation and its integrity, and therefore should not be anywhere near the top of the naughty list. But not only is it near the top of the naughty list, it's actually at the very top of it. And not only is it at the very top of it, it's at the very top by a long, long way. Not far from £6 billion in fines since the year 2010. Not 6 million, 6 billion in fines. The next worst offending industry is aerospace and military contracting. Most of that, by the way, is bribery. Next is telecoms. Most of that is bribery as well. But the reason I share this information with you is because of the next level of detail down. I'll show you. If you click on financial services, you'll then get to the top 10 offenders, several of which, as you can see, are household name banks. There we've got NatWest Group. NatWest was on the radio yesterday because, of course, the government is looking to sell it on. Interesting to see how the government's going to sell on a bank with such a terrible violations record. But the important data is actually the pattern that you see. What you're looking at now, folks, is the list of individual offences ranked by how big the fine is. And the third column in is the type of offence: anti-money laundering, insurance, internal controls deficiencies, mortgage abuses, etc., etc. None of it's particularly, righteous. It's all pretty seedy stuff. And remember, this is what they've been caught doing and prosecuted for. Lord knows how much other stuff hasn't yet actually got to or through the courts. The pattern is recidivism. Literally the same organisations doing the same things over and over again. This points to catastrophic regulatory failure. I say that, of course, because if the main purpose of regulation is to change and improve market behaviour, clearly this recidivist pattern shows that it's not working very well. I'll put a link to that in the chat in just a moment. Why am I mentioning this in the context of an event about slaps? Well, to bring that into context, I'm going to refer to a quote by Charlie Munger, Warren Buffett's right-hand man. Warren Buffett, the famous investor, of course. Charlie Munger said, "Show me the incentives and I'll show you the outcome." Now, remember, the figures you've just seen, those multi-million-pound fines, are a fraction of the amount of money that would have been generated by the misconduct. Show me the incentives and I'll show you the outcome. In the financial services space, the fraud, the banking misconduct, malpractice, misfeasance, and all the rest of it, the size of the prize, if I can put it in such crude ways, is so big that it literally pays to spend whatever you want to spend on any law firm you want to get them to buy the silence that they want, to enable them to continue doing what they may be doing. Of course, I'm not saying this just applies to banks. This applies to all kinds of criminal and antisocial behavior, malpractice, malfeasance, misconduct, mis-selling. And that's why it's so hard for those of us who are seriously tuned into the idea of promoting social justice and helping people to get redress and compensation, and frankly to reform the system so it's not so hard to do it. That's why we're all having to fight so strong. Our opponents are very highly motivated, very sophisticated, very well resourced, very well connected. You know, an extreme example springs to mind. A few months ago, we had the event about the Greensill scandal. You know, a former prime minister of our country, sufficiently motivated by money to do what many people would think was rather not very good. Thank you for giving me a chance to share all that. Don't forget that, folks. Show me the incentive and I'll show you the outcome. That's why people were literally willing to blow up a poor Maltese journalist. Mr. Nigel Kearns, thanks for your patience. You put your hand up a few minutes ago. Over to you, sir. Nigel.
Thank you. Yes, John's question to David regarding solicitors was very interesting to hear the explanation and reply to that question. But the same question for some of us might also apply to the legal departments of high street banks, where you don't necessarily deal with somebody that's a solicitor. If you are dealing with a solicitor, you don't necessarily know that you are. It's signed by the bank or somebody else. But they're dealing with, legal instruments in the same way that lawyers will. But they're not subject to the same, I would have thought, to the same SRA strictures as was described earlier on. So it seems to me that the legal departments of the major banks have got a sort of slightly privileged situation that allows them, to make abuses perhaps beyond those that are practiced by solicitors. Does anybody recognise? Does David recognise that scenario?
Could I chip in on that, if you don't mind, Nigel?
Yes.
You raised a really important point. And I'll be very keen to hear what David and others want to say about this as well. When the global financial crisis happened, something like 10,000 people lost their lives to suicide as a direct consequence of the global financial crisis. Not only, of course, did it cause economic and financial mayhem around the world, it caused human cost and suffering beyond words. Hence, people losing their jobs, losing their homes, losing their relationships, losing their families, and then literally killing themselves. I'll put a link to the Oxford University data about that in a moment. I'm not making these figures up, 10,000 people. We dedicated our book, Why We Must Rebuild Trust and Confidence in Financial Services. We dedicated that book to the 10,000 people who killed themselves. I mention it for a reason. Mark Carney, the former governor of the Bank of England, made a very clear statement. This is not verbatim, but the gist of it was the big learning from the global financial crisis was the complete lack of personal accountability. It was difficult to blame people because on paper they were blameless, they were not responsible. And that thinking from Mark Carney led to the very important progress called the Senior Managers Certification Regime. The Senior Manager Certification Regime, which was meant to be the regulatory solution to the inability to find people responsible for corporate actions. And you may or may not know, folks, that the Senior Manager Certification Regime has been used less than three times. I'm pretty sure I'm right, less than 3 times since it was introduced all those years ago. And I mention this in this context because of what Nigel just said. Just before the Senior Manager Certification Regime was introduced, the lawyers, understandably, show me the incentive, I'll show you the outcome. The lawyers pushed back and managed to get a carve-out. So lawyers in banks are not liable to the responsibilities under the Senior Managers Certification Regime. And as a consequence, what we see is when a bank wants to do something where a senior manager might be exposed because of the Senior Manager Certification Regime, that deed, that act is done by the chief counsel or somebody in his or her team, knowing they've effectively got immunisation from the liability and the personal responsibility that would otherwise be there. What we have here, folks, is a gaming of the system where the underlying driver is everybody looking out for their interests. That's okay. Human beings behave like human beings. No surprises there. But we must have a hierarchy of oversight, a regulatory regime, a judicial system that recognises human nature and recognises that people will game the system. I nearly use a stronger word. Game the system to look after their self-interest. And without that, they'll carry on doing it. Nigel, you've taken the conversation to a very interesting area. I see we've got hands up from Stephen and Richard. David, any comments in relation to what we've just been speaking about in the last 5 minutes or so? Great if you have. Don't worry if you haven't. We'll go to Stephen and Richard, but to you first, sir.
The only thing about using a lawyer, of course, the other advantage for a bank is that they can probably claim that the documents are legally privileged and don't have to be disclosed to you if you're bringing an action against the bank.
Yeah. The system is so fixed against the little guy, the David versus Goliath. Another quick example before we go to Stephen and to Richard. I believe I'm right in saying, folks, that when the Financial Ombudsman Service assesses a case, the banks will give their evidence to the Financial Ombudsman Service, but that evidence they give does not get disclosed to the claimant. And the FOS may make an adjudication based upon the bank's information and disclosure without the claimant ever seeing it and without the claimant ever even knowing that that was the basis upon which that potentially fraudulent, and being frank, potentially fraudulent disclosure may have taken place. It's truly shocking. We have a judicial system that is woefully inadequate in so many areas. Mr. Stephen Barker, for those of you that don't know, Stephen's a very important member of our Banking Victims Misconduct Group. The better Stephen, the better Richard Edmund. Mr. Barker, thank you.
Thank you. Just on that last point, if you'd listened to any of the inquiry into the sub-postmasters, you'd have heard a whole section over several days of how the post office instigated very early on a hub system to ensure that incriminating documents went through that system and could be treated as legal privilege and not disclosed. And it was organised.
Yeah.
And it's very clear. They even interviewed in the inquiry the lawyers that gave the advice on how to do that, because at first the post office was somewhat disorganised and realised they'd have to disclose a lot of incriminating information. So yes, that's a tactic, and the reality is you're dealing, if you like, with what we in the High Street would describe as a criminal organisation. Amazing when you think about it. No, can I come back to this whole question of slaps in the sense that it's fundamentally an equality of arms situation. I am not going to get a slap from my next door neighbour. He can't afford it any more than I can afford it. The difficulty is that the people that will start a slap have already determined I can't afford to defend it and they can afford to go the full 9 yards. Fine, that's the starting point. But let me just, if I may, just refer you to what's being discussed in TTF. And I hope, Andy, if you think this is inappropriate, Andy, you just tell me to shut up now, we'll do so. But we've been referred to very clearly Article 6 of the Convention with regard to the right of an individual to a fair hearing. The right to an individual of a fair hearing of their, if you like, prosecution case, or alternatively, the right to a fair hearing to defend a case. And the leading judgment, which is still current as far as I know, but David, you can check this out very easily, I'm sure, is, sorry, I'm just flicking through. I want to give you the right information. Gee whiz, I was just getting to the end. It's the case of Steele and Morris versus the United Kingdom. And this was a decision of 2015, May 2015. And it arose, I beg your pardon, 2005, not 2015, 2005. And this arose out of, and you'll remember this, I remember it anyway, the characters who were handing out leaflets outside McDonald's, complaining about the food quality and the damage to the planet that we're doing. And McDonald's didn't like it. And that's fair enough. So they decided to sue for defamation, which of course is one of the legal principles of slap actions, defamation, libel, you know, you're in that area of law. Anyway, these two characters, one was a single parent living on benefits, and the other was a person who was a sort of jobbing journalist. They were both kind of loosely connected to Greenpeace, but Greenpeace were very careful to disown them in the sense they didn't want to be part of the legal action. And of course, they lost in the English courts, and it ended up at the European court. And the European court, they brought an action under Article 34 of the Convention for the protection of human rights and fundamental freedoms. And their argument was that it was for the UK as a state to be prepared when the person is incapable of having a fair hearing because they cannot afford to employ lawyers who will understand the complexities of the case in question, that the UK were wrong not to facilitate that. And that whatever UK legislation said about legal aid, well, that was entirely up to the UK. But if the result of that was that these people couldn't get any assistance, then that was in contravention of their rights under the convention. And they won. They won, and they were awarded very modest, I'll call them damages, but very modest awards to recover some of their actual costs. But fundamentally, they hadn't got really large costs because nobody would help them. The whole legal profession, of course, didn't want to know because they couldn't pay anything. They couldn't pay their bills. They never would pay their bills. And we now, well, I say we, some of us, we now realise that we're not going to get a hearing in any court about what has happened to us. The postmasters didn't get a hearing and wouldn't have ever got a hearing if they hadn't somehow organised a criminal case and were successful in that. And they were fortunate that, when I say fortunate, they were fortunate in a legal case to have several of their members wrongly imprisoned on perjured evidence. We don't actually have anyone that's gone to prison yet in our group because the banks have destroyed us, and really that's all they're worried about. So it doesn't matter though. The potential for us to bring a case has been frustrated by the regulator, who's agreed with the banks that they can exclude us and not pay redress for irregular behaviour and move on. So our only source of redress was indeed for the regulator to use the extensive powers it's got to obtain what is called in the Act restitution. It just plainly refuses to do so. The Secretary of State, both the last government and already in correspondence with the new government, and I realise it's early days, they can't decide who the Secretary of State is that's referred to in the Act, but the Treasury have previously said it's the Secretary of State for Business and Trade, and the Department for Business and Trade deny it's them. So we'll get to the bottom of that eventually. Some Secretary of State has to be responsible for the duty placed on them by the Act. We also think that as a strategy, it might be useful for every one of us that are in this position to make an application for legal aid. It will be refused in the UK courts, but if enough of us make separate applications, and if enough of us look like we might get them back into the European Court, providing Britain does not come out of the convention, and I know there are forces at work in the previous government who want us out of the European Convention, and I have to say, I find that deeply suspicious that they want us out of it. The only people that benefit from that are the very people that are launching these slaps and other onerous and nefarious cases against individuals. It doesn't help us as citizens, as ordinary people. So my point here is that I think, in a way, because the UK government in the past, I don't say this will be Labour's continuing position, it's too early, but because the UK government in the past has allowed these things to happen and has ensured that we can't get to any kind of tribunal that is truly independent, like a court of law, we must have a good argument following the Steele case and judgment that our rights have been, well, they've been trodden on, quite frankly.
Stephen,
So that's where we're at.
Stephen, thank you very much. That Article 6 point is of enormous interest to us because it does seem as though our human rights are not being protected. Stephen, thank you very much.
Just before I go, a little aside, we also understand that a young barrister called Keir Starmer did provide some pro bono time for the claimants in the day. It may be 30 years ago, but you know what? He's done all right, and he's now Prime Minister.
Thanks, Stephen. Thank you very much. We're going to go to Richard, then to Steve Hubbard. We'll then be going back to David Hooper for his final words before we wrap the session up. So, Richard and Steve, if you can be reasonably succinct for me, please, that would be wonderful. Richard Emery, for those of you that don't know, Richard does a huge amount of work on a pro bono basis, helping people who've been scammed, people who are victims of serious financial crime. And he's probably, I'll say it, the country's leading expert on things like authorised push payment fraud, being on the telly, being on Moneybox, being on Radio 4. Richard Emery, thank you.
Thank you for your kind words, Andy, as ever, overplaying it, but I'll happily accept it. Just really picking up a couple of things. One is the whole David and Goliath. This is something that I'm seeing time and time again of an individual versus the bank. And it is a horrendous situation where an individual is unable to pursue a claim against the bank when the bank have very clearly done wrong. And let me just comment about the legal status. Comment was made about solicitors working in banks. The story really starts in very quickly. In 2018, the victims of the fraud paid £600,000 to the fraudster. I got involved in 2020. And one of the things that I discovered was that the bank had been given an instruction to make a CHAPS payment, but actually made an international payment to the Republic of Ireland, because of course CHAPS won't go outside of the UK. So in other words, the bank did not comply with the instruction given. During the course of my pursuing this in 2020, a member of the NatWest fraud investigation team, advised me that they did not consider a payment to Southern Ireland to be an international payment. In other words, they believed that the Southern Ireland was part of the United Kingdom, which is an interesting way of trying to avoid what they'd really done. Eventually, I climbed the ladder, and after 4 emails to their general counsel, their chief legal officer, I actually got a statement from him that said, I agree with all of the correspondence that you have had with members of the fraud team. Now, that email and the emails that I had where they were telling us lies about how the payment was processed now sit in a legal case, because after I'd been fighting it for 2 years, I ended up saying to the client, you're either going to have to walk away from £600,000 or you're going to have to litigate. We are 2 years into litigation, and the behaviour of the NatWest lawyers is an utter obfuscation. It is obstructive. It is creating paperwork. It is running up the cost bill. It is an utter disgrace. And quite frankly, the one thing that we have got to do is we have got to find a way whereby small people can take on big companies and have a fair hearing without ending up with an absolutely enormous cost base, whilst also, to be fair, protecting the big companies from vexatious claims which have no real basis. So there's got to be a big balancing act. So that's my sort of pitch on that front, because if you're small enough, you can go to the small claims court, as I've helped some people do. A lot of people can go to the Financial Ombudsman Service for all the problems that are associated with that. But if you fall outside of those arenas, you really have got nowhere to go. Can I just come and pick up, Andy, you made a comment about the relationship between the banks and FOS. So let me just endorse precisely what you said. I dealt with a complex technical case where there was, and I researched this with Cambridge University, there was a clear explanation for claiming that the individual did not authorize the transactions that were charged to his account. I set out a comprehensive document that explained how it had happened and what technical evidence they needed to look at. The Ombudsman Service asked my permission to send that information to the bank and invite the bank to comment. And of course, I gave my permission. But when the bank replied, they gagged FOS and said FOS was not allowed to show me their evidence. And that is an absolute travesty. It goes against our 20 years experience as an expert witness and the way in which the banks allowed themselves to accept evidence from a bank, which as far as I was concerned could be an absolute pack of lies, and I was not allowed to challenge it, is fundamentally wrong. And that's one of the areas that has to change.
Well said.
So that's my pitch.
Richard, well said, sir. Thank you very much indeed for your input. Thank you. Steve, you need to do the succinct
briefly
version. So less than a minute, please. Then I'll go to David for his final words. Thank you.
Very, very briefly, Andy, very, very briefly. I mean, we've heard about slaps tonight from David Hooper, and I'm very grateful for his insight into that. But you've also had events on corruption, on money laundering, on schemes of TTF and other things that you're involved in. And it's no longer an exception, it seems to me. It's the way the system works. It's what we do. I don't think it's an exception.
Well, thank you, Stephen.
It seems to me that that's just the system as it is.
Steve, I think
that's all I've got to say. Thank you.
It's kind of you to say that, and in so many ways, your comment just now teases up for the event on December the 6th, when John Bowers KC is going to be talking about the collapse of ethics and integrity and standards in relation to his book about the slippery slope of standards, effectively. So thank you, Stephen. Sure. We'll go to David Hooper for his final comments, and I'll just spend a minute or so wrapping things right up at the end. David, we've really enjoyed your participation tonight. We've learnt, we've listened, we've thought as a consequence of your work in your book. Thank you so much for being with us tonight, sir. David, any final comments from yourself, please? Thank you.
Just three very quick points. One of the things that people have talked about is the enormous cost of litigation. And one of the things I plan to do before the paperback of this book comes out is really to find out from lawyers in places like the Netherlands, Germany, France, why is it that things cost tens of thousands of euros or 20,000 euros that sort of cost £200,000 here? Because if we could make litigation cheaper, that would help. I think it would also help, and that's one of the things I've been agitating for, is I think, although you're slightly critical because of the scale of the operations of financial companies, but the fines are very substantial against them. In relation to solicitors, they're very, very low. Until recently, the maximum was 232,000. I think there's been one of 500,000, but that was in relation to money laundering, which is quite a serious matter. And the final point I wanted to make, which goes back to the point I was making, that if you use lawyers, that may stop you being able or having to disclose things, which of course banks like doing and organizations doing. There is an interesting judgment that's going to come out quite shortly. Andy Webb, who exposed the Bashir scandal of the Princess Diana interview, has been battling the BBC, who are as bad as everybody, who are failing to produce documents under the Freedom of Information Act, seemingly just to protect people's decorations and jobs. And willing to spend endless amounts of money, and it just happens to be your money that they're spending.
David, thank you very much indeed again for what you've done tonight. I've just put a note in the chat to ask our colleague Alexander, who you met yesterday, to introduce you to one of our very good legal contacts in the Netherlands, Hester Bays. She'll be a very good person for you to speak to about the relative costs, and Alexander will take care of that. Folks, we're going to bring the session to a close. I'm going to refer to a quotation I find myself very frequently referring to, because it says in so many ways what matters to us as campaigners. I hope you can see my screen. You know what? I think there must have been something in the air in the 60s when there was this sense of progressiveness and enlightenment and a vision for the future that was based on the kind of principles we were all, I guess, brought up with. Tonight's conversation has been about slaps. Slaps are a device used by the baddies to stop the truth from getting out there. They are therefore an anathema to all of us that want there to be high standards of conduct and integrity and ethics, and who don't fear the truth, who embrace the truth, who are desperate for the truth to get out there. It's very difficult to speak out sometimes. I spoke out in companies I worked for in the past, ended up losing my job on 3 occasions. We've got whistleblowers in our community who've spoken out and paid a huge price for doing so. And imagine how frightening it must be to receive a cease and desist letter or something like it from a law firm accusing you of doing things wrong when all you're actually trying to do is to tell the truth. This is a worrying thing. Maybe this government can make a difference. Who knows? I'll read this quotation out. I believe it to be true. Every time we turn our heads the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt, because we are too busy or too frightened, when we fail to speak up and speak out, we strike a blow against freedom and decency and justice. Ladies and gentlemen, slaps is a small but important part of the unfairness in the system that we collectively, as a campaigning collaborative community, are trying to deal with. And it's because of people like David Hooper with his expertise, and people like John Bowers, KC, and many of you with your various levels of expertise and knowledge and insight, that we can try to apply pressure in a rational, civilized, evidence-based way to say in various ways, the status quo ain't good enough and we want to change it. Ladies and gentlemen, thank you very much indeed. Can I please invite you once again to show your appreciation to tonight's author, Mr. David Hooper. David, thank you very much indeed. Thank you. Great session, David. Great session. Folks, it's very warm out there. I'm going to go and have a cup of tea or perhaps something else in the garden and cool off a bit. Thank you all very much indeed for your company tonight. Much appreciated. Good night all. Good night. Thank you.